Um, I had made a note to myself. Good thing I did. This new law really sets a new bar for Canada, and I'll describe to you exactly what I mean by that and who it applies to. But we will provide the 64-point checklist of new obligations. We will also provide a link to a recording of this session. Yeah, so let's start with the law itself. So a lot of people are under the perception that if I don't have an operation in Quebec, this law doesn't apply. And that's not quite how it works. So let me explain how it works. The law is really designed to protect the Quebec citizen. And in order to do so, they give the Quebec citizen a bunch of rights around how their personal information is used and not used. And it's a very consent-based law. So it doesn't matter if you have an office in Quebec or not. It only matters if you have Quebecers in your national database. And the last time I checked, Stats Canada said 22.5% of the population of Canada lives in Quebec. So the chances are pretty good if you maintain a national database that this law is going to have implications to your organization. So don't dismiss it just because you don't have full-on operations in Quebec. Really, the acid test is, do you capture and use Quebec citizens' data? So having said who it applies to, this law we're talking about today is the PPIPS, which is the private sector law for private sector organizations in Canada. So the one thing they did a few things different. So California, when they brought their new data protection law in, California said that you had to be doing $50 million a year or $25 million a year or maintain 50,000 people in your database. So it was a carve out for small business. Quebec didn't do that. Quebec has no carve out for small business. So it appears whether you're a two-person enterprise or a full-fledged, international company, you should be paying attention to this new private sector law. What else do you need to know about it? It was passed in September 2021, and they gave us 2 years, really, for it the main piece to come in force. So that comes in force this September. But they did the enforcement in 3 stages. Last September, they brought in two key things. The fact that the highest authority in your company is now accountable for all personal information captured and used by the company. So that means the CEO is on the hook. They're the first law in the world to do that. And I think that they noticed in the enforcement of the GDPR, I think they noticed that one of the more difficult parts of enforcing the GDPR in the EU and the UK was the fact that the C-suite hadn't bought in. And so they bought them in. Quebec made it mandatory and very prescriptive. The highest authority in the company is accountable for PI. It can be delegated, but at the end of the day, they are responsible. And the second thing that came into force last September that is significant and we believe will have enforcement impact significance is confidentiality incident reporting planning. So what that means is confidentiality incidents are what we would typically call a data privacy or security breach. And this law clearly states, as PEPITA does, that you have to have a documented reporting plan. You have to train your staff in understanding what to do in the case of a breach, a confidentiality incident, as they call it, and what all your written policies and procedures are. So that came into force last September. And that tells us that those two things are going to be some of the early fines from the Office of the Information, Access to Information Office in Quebec. It's called the CAI, that's the Commission to Access to Information, I believe, is it's CAI. They are given pretty broad enforcement powers to fine up to $25 million for breaches of this new law. And we believe they're going to be aggressive with it. We believe Quebec is serious about some of their stance on data protection for their citizens is even tougher than the GDPR. And I'll explain a little more where those finer points are. But the obvious one is most business in the GDPR is done under a lawful basis. There's really three available to the private sector. There's consent, there is contractual, and there is something called legitimate interest. So if it's in the legitimate interest of your company to do something, and it's not infringing on the rights of the citizen too severely, you have to do a weighing assessment. It's called the legitimate interest impact assessment. Quebec didn't include legitimate interest. And when you think about it, 95% of the business being done in the EU is under legitimate interest. So how are people going to do business in Quebec? How is it even going to be possible? Because if you have to get consent for everything, that's going to be tough to do. Your lists are going to be much smaller than they ever have been. And the people who interact with you are going to be just your core. We really work with marketers and organizations to try to get them to see that some of the practices that they've adopted in the last 25 years in the digital marketing space just aren't legal anymore. So changes to those practices have to happen. The risk to the business is just far too great. And now the risk to the CEO is far too great. So we're about to see some pretty significant changes. Our federal law is being updated as we speak. It is going through Parliament. It's not as heavy-handed as the Quebec law, so it makes the Quebec law really the new standard for Canada. So if I were operating a national company in Canada, I would be paying attention to Quebec's law because it is the toughest. So having said that, let's just share my screen and let's walk through the list. So I just mentioned the requirement to by default, the CEO, the highest authority, is the privacy officer, but they can delegate some of the tasks and to it. So to determine the qualifications required to fulfill the role of privacy officer, organizations should determine whether they have necessary in-house expertise or whether they need to hire somebody to perform the role or outsource the role. They establish the description and roles of the privacy officer. It should be documented. This description should take into account the requirements of Bill 64, or what we're now calling Law 25, and the reality of the organization. Much of the law is about proportion. So if you're a small 1 or 2 person firm, if you just have a really well-defined privacy policy and you really minimize the use of personal information of the people in your community, you're probably okay. But if you're a larger organization with a decent sized database, you've got a whole bunch of new obligations to pay attention to. So one of them is that you have to publish your contact information of your privacy officer on the organization's website. So you have to make it very easy for a consumer to know who to talk to and how to file a complaint or a request around privacy and their personal information. By September 2023, governance policies and practices regarding the protection of privacy information have to be documented and written and in place. Now, that's only a few months away now. So here we are in April, and this September, everything has to be documented. We do this with many of our clients. We walk them through how to build a policy and procedure manual and actually document and operationalize all the policies and procedures, but it takes time. So if you wait till September to start, chances are going to be pretty good that you have a gap, which is a potential risk to the company. So my advice is to start looking at this now. You still have 6 months before the meat of the law, or 5 months before the meat of the law comes into force. And 5 months will give you enough time to cover off the real key important things, like the things that came into force last September and the key things that are coming into force this September. You will not get your entire privacy management program in place between now and September, but you could get the more important things nailed down. You have to conduct an inventory of the policies and procedures in place to protect personal information throughout its life cycle. So from the point that you collect it to the point that you delete it and everything you do with it, including sharing it and using it in between, that all needs to be documented in a policy and procedure manual. For the most part, most companies we start working with, quite honestly, they don't even know where all their data lies. So the very first piece you've got to do is conduct a data mapping exercise to document the organization's personal information management practices. This exercise will be useful in developing the policies and procedures. So updating or establishing policies and procedures, which should establish roles and responsibilities of the organization's employees throughout the life cycle of the information. The organization should implement the following policies or incorporate them into an internal privacy framework. Policies setting out the general principles relating to the collection, use, and disclosure of personal information. What's your data retention policy? What is your data minimization policy? Do you collect more than you need to? And if you do, you should probably stop doing that, because the days of how Google started really was to collect everything and figure out what to do with it later. That's gone. That era is over. We now have to really think about the data we're collecting, and is it personal data? And if it is personal data, do we really need it? Like the aggregate BI, or business intelligence, that comes from aggregated data that's been de-identified or anonymized, that's different. But when you're actually profiling individuals and really looking at, their habits and trying to, market to them and build programs, personalized programs around them, that's what we're talking about here. So not the BI that comes from aggregate data that's used as part of your marketing strategy. That's brilliant. That's still available to all of us today. But when you have it right down to the individual, and you use that individual's information to customize or personalize advertising messages and marketing to them, now you're in the soup. So you need to have procedures for the destruction of personal information and how you anonymize it if you do. You need to have all your data security documented. How do you protect this information? Because clearly under these new laws, if you are going to capture and use it, you are required to protect it. I believe most of the fines, the early fines from the new Quebec law are going to be around two key factors. Actually, let's call it three, but one is the CEO will be fined. So we will see some examples very early in the enforcement, in our opinion, where companies are not fined, the CEO is fined. So that's the first piece. The second piece is because they brought that confidentiality incident reporting planning in first, we believe we're going to see a lot of fines for data breaches and security breaches. So the big stuff we read, like what Home Depot just did, you know, if anybody read about it, they collected your email address in order to send you a receipt, and they gave that email address to Meta in order to check if their ads were turning into sales. So, you know, this is all information a marketing department would love to have, but you have to stop and consider what the impact of using people's personal information are before you start rushing off and doing all these exciting things that computers allow us to do. And the third thing I think we're going to see fines for pretty early is no consent. So you've got the CEO being fined, you've got breaches and lack of consent, because the Quebec law depends heavily on consent. Now, as a privacy professional, I think it's a difficult standard to execute. Even the GDPR did not get that ambitious. They left that gap called legitimate interest so that companies could continue to do business, particularly in the B2B marketplace. But Quebec decided that if you're going to use people's personal information in any way, with a few exceptions, you have to have consent. And so the only two things available in Quebec are consent and contractual. So you can communicate with existing customers because that's part of fulfilling your contract. And that kind of communication completely doesn't require consent, does require an opt-out. So if somebody opens a bank account with you in order to communicate with them about their bank account, you should be able to SMS text them or email them or use their personal information. But if they request that you stop doing that, you must stop. So Quebec is switching from an opt-out environment, which is what I just described. They're moving to an opt-in. So if, like Castle, if you don't have consent to send somebody an email, you're not allowed to under Castle. Same thing will apply in Quebec or under this new Quebec law. If you can, if you are profiling somebody and trying to build a profile of them, and you need their consent in order to do that. So in theory, Facebook really can't do what they've always done in Quebec after this law comes into force. So it's going to be interesting to see how it's enforced and, you know, how big a bite they can take. Clearly, under the GDPR, Meta's business model is in jeopardy. The Irish authority has just fined Meta for like $50 million, I believe, for transferring information and for not having consent to profile. And so that it is starting, the circle's getting smaller around Meta and what they can and can't do with data. And, you know, as businesses, we've just watched them and Google and said, well, if they can do it, we can do it. with no consideration to the impact on the individual. And I think that that's the biggest single thing that's changing. One of the other obligations is that you have to develop a privacy training program. So all your staff have to be trained in who's your organization about privacy. How do you handle it? What do you do? And that training has to be specific to you and your company, and it has to be delivered to your staff. And it has to be documented that it was delivered so that you can prove it. Again, without these laws being enforced, it was irrelevant whether you could prove it or not. So nobody documented it, or few people did. And certainly, if your staff were trained, documenting the training schedule and having people sign off that they were trained in privacy and in security has never been a requirement. Now it is. So it's a new obligation brought forth by a data protection law. They are not about to believe that you have a policy manual unless you can show it to them. And they are not about to believe that you trained your staff unless you can prove it with data logs and et cetera. So you just have to get creative and start thinking through how are you going to document and prove all of this. All of these policies, procedures, and training have to be approved by the privacy officer and now the highest authority, the CEO. Publish details, information about these on the organization's website. So that can show up in many different ways, but most of us call it a privacy policy. I'm gonna start to use the right language. It's actually a privacy statement. So what most people on their website call a privacy policy, you should change the name of that and call it your privacy statement, because it's your statement to and promise to the world of how you handle personal information. And you can do a really good job summarizing that in plain language so that people know exactly what is and isn't done with their personal information when they're dealing with you. That's going to build trust again with the consumer, because the last 25 years, we've taken such advantage as a business community, collectively, we've taken such advantage of people's personal information that they no longer trust many brands with their information, because they know they're going to do the wrong thing with it. They know we have not been wired to do the right thing. And I think in order to win that trust back, we've got to be very transparent about what we do and don't do with data, how we handle it, and how we respect the individual. There's a person behind all that data. And we haven't really acted like that in the last 25 years. And we're ushering in a new period or a new era where that's going to be important. One of the other things that you should know is that a privacy impact assessment has to be developed. And a privacy impact assessment is anytime there's a major change to your network, you add new fields that you're capturing, you add a new software program that captures personal information in some way inside the app. A full privacy impact assessment must be done. So what the government's asking for is think it through before you just slap this new software program in place or software as a service. Think it through. Think about the data you're collecting. Do you need it? And if you don't need it, turn that off. Think about, if you do need it, how are you going to use it? What's the impact to the individual? How am I going to secure it? That's doing a privacy impact assessment. It's actually thinking through the entire impact of you collecting and using someone's data. What could go wrong? If it was breached, how could that impact the individual? All this has to be thought through and documented, because a privacy impact assessment should be available to the CI, to the enforcement body, upon request. So you don't have to file them every time you do one, but you should have them in your supporting documents so that if the guy ever comes to you and says, show me the privacy impact assessment you did when you added this software to your suite, or when you made this major change to your network, show me the privacy impact assessment that you conducted. And if you can't show them, you will be fined. So I'm going to add that to the list of things that we can see early fines for. No PIA is probably the fourth or fifth thing on that list that you'll see some early fines for. We do have PIA templates and can help you design them if you're not sure how to do them. We have a full privacy policy manual template that we like to use with our clients. It's got 125 different policies and procedures across 500 pages, covering 18 or 17 or 18 different sections. So pretty much all we've talked about here and all the new obligations under these new laws are covered in the privacy manual. I have had the pleasure this past 3 or 4 years to sit on the Canadian delegation for ISO to build or actually write the ISO standard for privacy by design and default for consumer products. And what I noticed in that process is privacy by design is really built into most of these laws, and Quebec is no exception. Privacy by design is the 7 principles of privacy by design are the fundamental backbone of the Quebec law. So if you have not had a chance to look that up, Anne Kavukian developed, our former privacy commissioner for Ontario. She developed years ago privacy by design. And if you Google it, it will reveal the 7 principles, and they're quite fundamental. If you really want to put a rudimentary program, like a real basic sticks and stones program together, follow the 7 principles of privacy by design, and you'll at least be doing the right thing. Even if it's not all documented and everything the way it should be, you'll at least be doing the right practices. So you'll get in less trouble. The next thing I should talk about is the Quebec citizens' rights. They have, under this new law, they've been granted a whole bunch of new rights. And we've had this in Canada, but not enforced through PIPEDA or PIPEDA since 1999. You have been able to go to a brand or an organization and say, what information do you know about me? And that brand is obligated to tell you what personal information they hold about you. And that was a feature in the new GDPR, and globally when the GDPR went in force, we all got more requests for, access to information. And I think that as this Quebec law comes into force, you're going to see the quantity go up here in Canada, because the right to access the information held by an organization is a very dominant and very important new privacy right in Quebec. But also, you can ask that company to change that information, or indeed to delete it if you don't want them to have it anymore. So I could call Rogers and ask for what information they have on me, and I can then ask them to delete me from their entire system. Now, every company legally now has to be able to tell people what information they have. And when you don't know where all your information is, it's really hard to tell an individual what you know about them accurately. And if you don't do it accurately, you could be fined. But more important, when they ask to delete it, you have to be able to prove that you deleted it. So new practices and systems have to be set up so that you can fulfill on all of these new rights. One of the other things that I should mention is transferring Quebec citizens' data outside of Quebec is a problem because you're responsible for it being protected to the level of Quebec. So if you, for example, if you use HubSpot or Salesforce and your instance is in the US cloud and you transfer Quebecers' information to a US cloud, you've now exposed it to a privacy or a data protection environment that's nowhere even close to Quebec's. So you're now responsible for that person's data. And if anything is done with it in the US, you could be held accountable. So we're going to see a lot more instances of clouds being located in Quebec, in Montreal, and Quebec City. And I believe that most Canadian cloud versions will be housed not in Toronto but in Quebec because Quebec's standard is a little bit higher. So look for some changes in this direction as well, because transferring data outside your provincial lines is going to be an issue. The other thing, and it's included in this complete list of PPIPS compliance checklist, but the other thing that you have to have in place is all of your third-party suppliers around you. Anybody who touches the personal information or uses it in any way to help you execute, you have to have very clear data protection clauses within your agreement with them. And many of our old contracts with third parties don't include data protection clauses. And this new law requires you to have very clear standards between you and your third parties as to how people's data is protected and treated. We have a chat or a question came in on the chat. If you have questions, start putting them into the Q&A and I'll do my best to answer them. But Catherine's asking, when does it suffice to disclose the categories of third persons and when they're named? Really, the best time to disclose it and the time that the law states is at the point of collection. So in a perfect world, you would tell them that you share it with your party, your third-party partners, and you would give a link to a list of the third-party partners that you share it with. That's in a perfect world. Now, many of us are not that well organized and we don't have it down that flat yet. So that might be a year two a program, part of your privacy management program. But in theory, it is something that's in the law. I'm not sure, Catherine, that this is going to be one of the early enforcement points. But technically, you should be that transparent to for your community. I hope that answered your question. Okay. Yeah. So I think that did answer your question. So my apologies. I was hoping to learn when it is sufficient to disclose just the category as opposed to the name of the third person. Again, at the point of collection. It should be very clear to people what you're collecting, why you're collecting it, and how you're going to use it, and who you share it with. So it's no longer sufficient to bury that in a privacy policy. Facebook's privacy policy is thicker than Macbeth, and nobody reads it. So the government is now, starting with the GDPR, the governments are taking the position that if the person who signed up for something doesn't know they signed up for it, they didn't sign up for it. So it's pretty simple. It's no longer a legal cover your ass. It is find a way to communicate exactly what you do, what you collect, what you do with it, who you share it with, and when you delete it, and communicate that to your community. Transparency and accountability are forefront in these new data protection laws, and I believe the enforcement of them is what's going to make the law much more relevant in our day-to-day practices. None of us need to take the risks that these laws present. So, along with your CEO being fined, nobody wants the corporation to be fined. Nobody wants to be breaking the law. So, I think what we're going to see is a lot more attention to your privacy governance framework and your privacy management program than we've at all seen in the past. And fair enough. We didn't really, beginning in like the mid '90s, when we realized how much data we could collect and what we could do with it and what the computers were allowing us to do, we didn't really think it through. We really didn't, do a 360 assessment of, well, what could go wrong? And the fact that we didn't do it voluntarily, that the government is now stepping in order to protect citizens' personal information and their rights and freedoms. They are stepping in and saying, all right, if we're not going to do this voluntarily as a business community, in order to garner trust with our consumers, we're going to force you to. We're going to put laws in place that have a minimum standard when it comes to what you can and can't do with people's data. Now, unfortunately, it took 25 years of abusing it for us to realize that, the problems we caused in doing so. So this is the long-needed correction and long-awaited for correction. Now, we're seeing this all over the world. This is not unique to Canada. The U.S. is resisting, but I think they're breaking down now because state by state they're introducing new laws to protect the citizens of those states. So the U.S. is going to end up with a patchwork of privacy, just as we are here in Canada. We're going to have a patchwork between provincial and federal standards. Right now, there is an Ontario privacy law about to be introduced, and it looks like, from early indications of what we've seen, it's going to lean more towards the Quebec standard than our new federal standard. In my opinion, our new federal standard is far too weak. Facebook can continue to do almost everything it does today under our new federal proposed law, Bill C-27, and I think they're just far too liberal, or far too. I didn't mean liberal as a capital L, but far. It really leaves things way too open and way too much to a company's interpretation, and really counts on the company to do the right thing. We've had 25 years of knowing that the companies aren't going to do the right thing. We're in competitive environments with quarterly reports and huge executive compensation all on the line. There's no way that if we think we can gather data and use it to help us do business in this environment, in this business environment, without data protection laws, there's no way we're going to resist it. And our federal law seems to be taking the position that that data protection equals lack of innovation. And I actually think it's the opposite. If you level the playing field so we are all playing by the same rules, innovation is going to flourish. Because within that, the guardrails set by the data protection law, now you can be innovative. But without this, I think it's just going to be chaos. So I'd love to hear any of your thoughts in the chat or any questions you may have. And I'm happy to send this PPS compliance checklist to whoever would like it. So simply reach out to me. My email address is dlackey, DLACKEY, at Newport Thompson. That's NEWPORTTHOMSON.com. And I'd be happy to send you this PDF so that you can begin to speak internally about where your gaps might be, where your problems might be. And if you require, I'm happy to hop on a call with you and your team members at no cost to talk about some of the things that you're really worried about within your own organization and what you think the priorities should be. I'm happy to hop on a Zoom call with you and your team and specifically discuss your circumstances and your situation, and see if we can kind of figure out where at a very 30,000 foot level you might have a little more risk than you're willing to take. So let's keep going on here down the list a little bit. Prepare an inventory of technologies that collect personal information from clients and employees that can identify, locate, or profile them. So you literally have to have a list, a log of all of your technologies that you use that capture personal information. Again, we all have a marketing stack, and we all have, different technologies inside that touches the personal information we collect. Now you're required to actually document what those are. Again, these laws are requiring you to really know what PI you capture and use. Many of our clients, when they first started working with us, they didn't have data retention strategies. They didn't have a date by which that data would be destroyed or deleted. And I think Revenue Canada requires us here in Canada to keep transactional information, like financial information, for 7 years. But after that, there becomes very little reason to continue to hold that kind of information. We had an e-commerce company that started 21 years ago, and they still have transactional data from 21 years ago. And it's stored in a place with online access to it. So that could be breached, and all sorts of information that's of absolutely no use to that organization today could get out into the dark web and cause impact on the people that PI belongs to. This is another good one. Consent requirements, form validity, and minors. So there is a type of personal information called sensitive, and a very key area of that is minors. So in Quebec, they've said under the age of 14. And again, I believe they're going to crack down really hard on people who collect information of anybody under the age of 14 and be sure that parental consent and all of that is documented and in place. And if it's not, I think you are going to see some significant fines for overuse. So TikTok, for example, will be in trouble under this new law because they absolutely intend and aim to minors under 14. And that's going to come with a whole new set of transparency, obligations, accountability, and new documentation, and a whole new set of practices. So again, social media developed during a time when, there was the Wild West of digital media. And the practices that they put in place back in 2003 till today had no regulations. They now are going to have regulations. How that's going to affect the platforms that already exist remains to be seen, but I think it's going to weaken them. I think it's going to force them to change their business model, as Facebook has been scrambling to do since the GDPR was introduced. And the governments, I think, are giving them time to make those changes, but they have to see progress. And they're going to be the same with us in the business community. They'll give us time to put these programs in place and to change our practices, but they want to see progress and they want to see documentation. And they want to know that you're respecting people's privacy and their rights. So again, if you have any specific questions, please fire them off and I'll answer them. Otherwise, I think from here, this just starts to give you a taste of the new obligations. And here are the exceptions to the consent requirement. So in Quebec, if you're using it for the prevention and detection of fraud or to evaluate and improve security measures, so there are carve-outs, but for the most part, if you're going to use somebody's personal information in order to further your business, you have to have consent. And that consent has to be meaningful, meaning that they have to know what they gave consent for. So I know we've got some publishers on the line here. The old days of just collecting data and doing your own thing, you're going to have to up your game a bit. You're going to need meaningful consent from the individual to do some of the things that we've always done. Lots of logs to be kept. There is a consent exception for research and internal research and analytics. You can anonymize all this data and turn it into business intelligence and use it all day long. As long as you can't re-identify the individual behind the data, that's all legitimate, business intelligence data that is critical to most of our business operations. But being able to drill down to a person. I watched a session from the EDPB in the EU with Johnny Ryan from Ireland, talking about an organization that had actually created a tag to find people with a particular disease so that they could market their pharma products to people with that disease. And, whether or not I have that disease or that condition is very personal. That is what all of the data protection laws call sensitive data. Information about my health is my business, and who I want to reveal it to is my business, and it's not up for grabs for you guys in order to sell me stuff. Catherine, I'll rephrase. How do I determine whether I need to disclose a third party's name versus the category of the third party under Section 8? Can I say, we will disclose your information to credit report agencies for the purposes of XYZ, or do I need to say, we'll disclose your information to Equifax? I believe the law gets down to naming the people you're going to share with, Equifax and TransUnion, and I believe the law is asking you to be that level of transparent. Now, I'd have to go back, Catherine, and search specifically for your question, but I remember as I read and reread and commented on all of the various sections, I remembered believing that this was a level of transparency that none of us were used to. So you could probably get away with, we will disclose your information to credit report agencies, because that's clear enough. But I think the CI would really like to see you take it to the point where you actually list the companies, because I might be okay with you giving it to Equifax, but not TransUnion or vice versa. And I should be able to ask you not to share. That's one of the rights I have, is to ask you not to share my data with a particular brand that I don't have any confidence in. So Equifax has been breached several times and continue to be breached. So if somebody told me they were sending my personal information to Equifax, I would actually file a written request not to do so, based on what I've seen. Marriott is in the same boat. So if somebody told me they were going to reveal my personal information to Marriott, I would ask them not to. Catherine says the law allows for both. If applicable, the person concerned is informed of the names of the third party or categories of third person. So while that section says that, Catherine, I agree with you. It gets covered off in other parts of the law that actually contradict that. So that's what I would need to look up. So I'm clear that you found the section that said that you're allowed to do this. I believe in other parts of the law, they made it clear that they would like you to go right to the level of who you're sharing it with. And I know the GDPR does for sure. The GDPR, that is a requirement to list who you share with. And upon request, make that list available to the consumer. Good. I think we finally got to the bottom of that one, Catherine. And again, if you want to contact me outside of this, I'll go in and look for those particular parts of the law and see if I can get a little more rigor around this. So again, we're almost reached the top of the hour. And unless you guys have any more questions, I'll wrap this up. Please don't hesitate to contact me if you would like a copy of this PPI compliance checklist. It just goes through all of the things that your company should be thinking about. You have to prioritize them, and we can certainly help prioritize them against the laws by just a quick discussion of what your current practices are today and where your gaps might be and what things that you should maybe consider rethinking before September. So again, Lackey at newportthompson.com. Happy to answer any specific questions and send out this checklist to anybody who wishes it. I thank you for your time today, and I give you back 4 minutes. It is now 56 on the hour. Thank you very much, and have a great day.